Yes, good morning to everybody. The class is in progress now. This is the repetition class for the students, those who are sitting for the regular COVID examinations of the interpretation of statutes. And as per I posted that I told you that today in this class that I would like to deal as much as for the strict construction of the penal statutes as well as the strict construction of the taxing statutes. So these are the things which I want to make it out. Before I could proceed further, I would like to get it whether that you are could hear my voice as well as could see my screen, which I posted on the slide on the screen. Please read what is posted on the screen so that I could know that you are with me and I am with you. Yes, Narendra Raju, please do the same thing.
Good morning, sir.
Very morning. Please read what I posted on the screen.
Broad classification.
Okay, thank you. Excuse me. Yeah.
Cardinal rules of interpretation.
Okay.
Literal interpretation.
Okay.
Interpretation of income tax.
Okay. These are
Golden
the
rule.
broad classifications are there. You can get the screenshot that may be useful to you.
Okay.
Excuse me. Because I sat in the different room, it is having a big dust, it seems. That's why I'm getting the cough. Anyway, that you unmute, you mute it now so that I could go to the class directly. Yeah, you take the screenshot. It may be useful to you in nutshell. Of course, I'm going to share it tomorrow also in the group. Yes, coming to our study is concerned, yes, this is the thing, the strict construction of the penal statutes. So introduction is it the repetition class. That's why I'm a bit fast so that I could complete it within the stipulated time. So, in a penal statute, if there appears to be a reasonable dubiety or ambiguity, that is, the two words are there, dubiety or ambiguity, it shall be decided in favor of the person who is liable to be penalization. So, if a penal provisions fail to be so construed as to avoid the punishment, it must be so interpreted. If there can be two reasonable interpretations of the penal provisions, the more lenient should be made applicable. So, whenever the penal statutes are made over there, the parliamentarian should have take a lot of care in enacting the penal statutes. The reason is it penalizes the person who is a wrongdoer, rather I can say the accused person or the person who is involved in the crime or that is the reason. Suppose if there are two interpretations are available over there, at the time the court will be lenient towards the imposing the punishment. So lenient punishment will be taken into consideration rather than the hard one. So punishment can be meted to one only if the plain words extension of the meaning of the word is allowed. Please unmute. Please mute it, because I'm getting your sounds. Yes, mute them all. Yeah. So punishment can be meted to one only if the plain words extension of the meaning of the word is allowable. A penalty cannot be imposed on the basis that the object of the statute so designed. So what I want to say here is the penal statute, whenever the parliament are enacting it, they have to very much strictly follow the words, and the words should not give the two meanings. Where the two interpretations cannot be possible over there. That's the reason the penal statute should be fixed and construed with strictly in the same manner like the taxing statute, which is nothing but a penal, what I say, punishment in the form of the money. So that is the only panacea is there for the punishment over there. But the here penal statute, it is a punishment, corporal punishment will be more. So according to the Maxwell, let us see that how the construction should be there for the penal statute. Number one, express language is necessary for the creation of the criminal offences. Therefore, no act is to be deemed criminal unless it is clearly made so by words of the statute concerned. But it is not necessary that a particular penalty be specified in order that an act or omission may be constituted an offence. So that is the first principle or first point. The second point is the words setting out the elements of an offence are to be strictly construed, and if there is any reasonable doubt or ambiguity, it will be resolved in favor of the person charged. So if the two views are there, then generally the lenient view will be taken into consideration when they're charging the person. A reasonable interpretation which will be awarded the penalty must be adopted. If there are two reasonable constructions, the court may give the more lenient one. The court may always see that the person to be penalized come fairly and squarely with the plain words of the enactment. I repeat that the court must always see that the person to be penalized comes fairly and squarely within the plain words of the enactment. Number third, punishment can be imposed only if the circumstances of the case fall clearly within the word of the enactment. But exactly what the statute said that the person should be charged would squarely and fairly come within the parameter. That is the point. The fourth one is similarly the statute dealing with the jurisdictions and procedures are, if they relate to the infliction of the penalty, is strictly construed. The general rule is that all penal statute must be strictly construed. That is actually the thing, according to the Maxwell. According to the Lord Escher, that is, its settled rule of the construction of penal section is that if there is a reasonable interpretation which will award the penalty in any particular case, we must adopt the construction. If there are two reasonable constructions, we must give the more lenient one, as I said in the Maxwell also they said the same thing. So let us see some of the judicial decisions, how the penal statutes will work. So in the case of the M.U. Joshi versus M.V. Shimpi, this is the case law. The appellant was convicted under the section 16 of the Prevention of Food Adulteration Act in 1954 for selling the adulterated butter. So what is the punishment? Of course, punishment as per the section 16 of the Prevention of Food Adulteration Act 1954. So what is the selling? The adulterated butter. So now he contended that it was not a butter. Who contended that? The person who was charged contended that, means shopkeeper contended that it was not the butter within the meanings of the rule made under the act, because butter means butter made from the milk, whereas he had sold the butter made from the curd. So now you tell me butter could be made from what is the ingredient for the making the butter? Anyone can unmute and give me the answer so that I could proceed. Yes.
Sir, curd is needed, sir.
Can't we made the butter from the milk?
Yes, sir. Milk after boiling and later it turns into curd, and curd can be made into the butter.
There are two ways. One can get the butter directly from the milk. One can get the butter directly from the curd. So now, because you skim it, they will remove the cream and they will keep it aside. They will make it to the butter later part. But another thing is that the traditional thing is you will make to the curd later on, that if you skim it, then you will get the butter. So there are the two ways to get the butter. The Supreme Court, whether it is made from the milk or made from the curd, the Supreme Court made while rejecting the contention that held that the strict construction means that the conduct of the accused for this conviction must be fall within the plain words of the penal statute without straining the natural meaning. Butter means butter, whether it is made with the curd or made with the milk, doesn't make any difference. Whether adulterated butter is there or not, whether it is made with the curd or made with the milk is not the question to be considered. So in the present case, the word butter is a clear that cannot be two meaning of it. Therefore, the question of interpreting it in favor of the subject does not arise. The contention of the complaint that butter made from the curd is not covered under the rule and made under the act does not stand, because butter is a butter, whether it is made of the curd or made of the butter, made from the milk. So butter is a butter whether made from the milk or curd. The intention of the legislature is quite clear from the language it has used, and there is no room for the doubt. So butter means butter whether it is made from the curd or made from the milk. It doesn't make any difference. So the son is a son, whether you will say the father name, whether you say the mother name, doesn't make any difference. When illegitimate is there, at the time it is goes with the mother, the father will not come into the consideration. So that was the very much clear in that aspect. If there are two reasonable constructions, the court may give the more lenient one. Suppose there are the interpretations are there, then the court will generally take the more lenient one, and it will be charged on the person who will be charged under the act. So it was observed in the case of the Ratanlal versus State of Punjab. The accused, a 16 years old boy, was convicted for outraging the modesty of a girl aged 7 years after having committed the house trespass. So he was charged under the outraging the modesty of a girl under the 7 years, who the 16 years old boy was convicted for the offense committed the house trespass also. The magistrate awarded him the imprisonment for the 6 months and fine. Of course, before it is going to be finalized over there, it took the long time also for the disposal of the case, but finally the magistrate awarded him the punishment of the 6 months and fine on this 16 years old boy. After this sentence was passed, of course, sentence was passed by the court. The Prohibition Offenders Act 1958 came into existence. Later on, the 1958 Prohibition Offenders Act came into existence. As per the new act, based on the section 6 of the restrictions on the imprisonment of the offender under 21 years of the age. So there they put it the restriction, a person should have to be at least 21 years of age to get such an infliction of the section 6. Based on the age, ground of the accused pleaded to the additional session judge. So his age is less at the time, but he took the advantage of the section 6 because the section 6 clearly say 21 years age. So he took the advantage of that one, then he based his appeal, the additional session judge, then to the High Court. Of course, the additional session judge rejected it, then to the High Court, and the revision without claiming benefit under the Prohibition Offender Act. So, in the both the places, he could not get the benefit of it. After that, the High Court rejected his revision and he pleaded before the Supreme Court. Finally, that a person approached the Supreme Court for the benefit of the Section 6 and he has below the 21 years in the age. The Supreme Court by majority held that the benefit of the probation could be given to him. So here the benefit is given to him because the boy is a boy, because with the somebody is instigated or the party instigated or whatever the case would be there, this boy and who is going to be a nation's tomorrow backbone, hence the court has given the lenient view and they applied the section 6 of the Prohibition Offenders Act and give the benefit. So in certain cases, because the boy is the minor, he has given the beneficial legislation aspect that is given over there. But generally, whenever the criminal statutes are there, it should not be a retrospective effect. It is only the prospective effect. But here, for the benefit of the child, it is extended to it, and this is benefit is given to the child here in this case, because today child is their tomorrow's backbone, because the child, because of any other activity which is committed in such an offense, whether intentionally or voluntarily, the other party has made the instigated it or encouraged it, later on they become a what I say enemy or denied it. First they would have given the consent, later may have denied it. I believe that may be the reasons. The possibility would be there is the criminal actions generally that court will consider beyond the reasonable doubt. That the doctrine they will follow it, so that they administer the criminal justice in the entire India also. So now let us come to the next case, like the Alamgiri versus State of BR. And the wife left her husband voluntarily for her free will, came to stay with the appellant on the question whether the appellant was guilty of an offense under section 498 IPC. It was held that the detention in the context must be mean keeping the back a wife from her husband or any other person having the care of her on behalf of her husband with the requisite intention, and hence the appellant was held liable under section 498 IPC. So here the 498 IPC would be there. Suppose somebody wife came voluntarily to your house and you are a married man and you are staying with her. Him with his own consent, can the amount of detention, the word they clearly court say yes, it is a detention, because you know that she is the wife of somebody else, but still you are staying with her and it is nothing but the bigamy that you did it in one way, in another way. Hence, section 498 will be applicable over there, but strictly construed. But the meaning will not be that she came according to her own will, but she knows. But you know, because you are a married man, and Of course, you are not a married man also doesn't make any difference because if you know that she's a wife of somebody else at the time, but still you have the living with her and having the BBC and so on so forth, but you will come under the section 498 of the IPC. Another case like the Chinibai versus State of Bombay, the several workers in a factory died by inhaling the poisonous gas when they entered into the pit in the factory premises to stop the leakage of the poisonous gas from the machine there. The inspector of the factories on inspection did find the beating and revising the apparatus and stating that not to enter into the premises, but the belts and ropes are in fact in violation of the section 44 of the Factories Act 1948. The person has violated it. The question of whether the employer violated the section 3 of the act, which says that no person in any other factory shall be permitted to the Factories Act 1948, does not impose an absolute duty on the employer to prevent entry or person in any area where dangerous fumes are likely to be exist. So the mere fact that the some workers went inside the pit does not prove that they are the permitted where the employer to enter. The prosecution must prove that the first before the any defense was called. Since the prosecution failed in this duty, the employer could not be convicted. Could not be convicted. So here the point goes over there. Suppose if the prohibition would be there in the factory and the will is clearly meant over there, nobody should have entered into the premises. At that instance, if any person has entered the premises, violation of these orders given by the employer, at that instance, the employer could not be convicted because they clearly given the warning over there. The toxic fumes are over there, and hence nobody would have entered into the pit. That means strictly they have to follow it. Suppose if somebody has went because is a voluntary not fit injury could be applicable over there. So that is the reason here the employer is not held liable for the conviction. Let us see the another case law. Sarju Prasad versus State of Uttar Pradesh. The apparent who was an employee in the shop was convicted of the Prevention of Food Adulteration Act 1954 for having sold adulterated food. What is adulterated food? Let us see that. He argued that since he did not know the food sold by him was adulterated, he could not be convicted under the Section 16 of the Act because of the enactment being the penal statute had to be strictly interpreted. Section 16 which penalizes the selling of the adulterated food, and Section 19 which says that the absence of the guilty knowledge is not a defense for interpreted by the court. The provision clearly states that the knowledge on the part of the seller is absolutely immaterial for the purpose of the conviction, therefore the apparent appeal must fail. Suppose if you know that the material which you are selling is adulterated or not. No, you are supposed to know it whether it is adulterated or not. Because you cannot make the presumption that see somebody has sold it that I put it over there that I am selling now. No, before you are selling it, you have to check it whether it is adulterated food or not. If it is adulterated and if you knew it, then naturally the section will be attracted to you. But you cannot take the plea that I did not have the knowledge of it. Because the knowledge you should have to must have the mandatory when you're selling a particular goods in your shop. Is it clear? At least say yes, so
Yes,
that
sir.
I could proceed. Good. So now let us move further. Then, so whenever you are selling anything in your shop, first is your primary duty that you should have to know that what you are selling is adulterated or not. But you should not take the defense that I did not have the knowledge of it. Let us see the another case law, Ranjit Udeshi versus State of Maharashtra. The appellant was convicted under the Section 292 Indian Penal Code by the High Court for selling the obscene book titled Lady Chartier's Lovers, written by D.H. Clarence. Of course, D.H. Clarence has written a novel, Lady Chartier's Lover, and there are some pornography is there, absent literature is there. So, because India is a civilization, they want to keep it out, and the pornography will not be made like a Playboy, which is a journal, or Debonair, which is a journal where the sex photos would be given over there, but such a thing is banned in India because it will provoke it, and because the Indian culture will not make it very obvious like reading a novel, a fiction. So this Lady Chartley's Lovers, written by the D.H. Clarence, was banned by the government of India. When it is banned by the government of India, that nobody should have to sell it or read it. Suppose the reading and selling everything would be banned over there. At that instance, the person is selling such a book, and the person, the owner says that he did not have the knowledge that it is banned over. And he did not even see that what is the inside of the lady chatter's lover, whether photographs are there or literature is there regarding the pornography is concerned. The accused contended before the Supreme Court that mens rea of the accused always to be proved to maintain the conviction under the criminal law. So in the criminal law, whether mens rea is there or not, we can see it. But the Supreme Court rejected this argument and held that on a plain reading of the section 292, it is clear proof that the mens rea is not required for the conviction under this section. Mere selling or keeping of the sale or obscene of literature has been made punishable when it is government of India has made it clear the appellant is guilty on the basis of the plain reading of the enactment of the therefore this appeal must not be succeeded. But he cannot take the plea that he doesn't have the mens rea. But it is very much clear that the government of India is banned such a ladies' chatter's lover, which is written by D.H. Lawrence. Then we are not supposed to sell that book, even that he read it or may not read it, he has seen it, may not seen it, whether the pornography is there or may not be there. Before he is selling, he should not supposed to sell such a book, which is banned by the government of India. So that is the case law. And another case law, the Sweetie versus Parsley, there is absolute liability case law. Sweet versus Parsley, where the mens rea is statutory offense and the Dangerous Act 1965. The facts of the case law goes like this one. The appellant, the Stephanie Sweet, yes, and she was a teacher, was a subtenant of a farmhouse, and the farmhouse she stayed over there, and where the cannabis resin was found, and the Sweet no longer lived in the house, but he let out her several rooms to tenants, and she did it retain a room, but only returned occasionally to collect the letters and prints. But she was not staying over there, but once in a week or once in a month, he will come and collect whether any letters are there in the post box or not. The appellant was charged and the convicted under Section 5B of the Dangerous Drugs Act in 1965 because of the subtenants, those who are taken the rooms, which are the most the students, they are using the cannabis or psychopathic substance. Cannabis is a psychopathic substance like the brown sugar, heroin, and charas. And even including the ganja, which being a concern with the management of the premises used for the purpose of smoking cannabis resin. So the lady which has given the rent, she doesn't have any knowledge what the students are doing over there because occasionally she comes over there just to pick up the letters from the letter box. At that instance, he said, I did not have any intention to give any such anything, but such a thing also going on in my premises, I did not have the knowledge of it, and hence she will not be convicted for this offense of this absolute liability. So Section 5B of the 1965 Act makes no reference to the mens rea required for the offense. The issue in the question for the appeal court were whether the Section 5B created an absolute offense. Number two, if not, what was the requisite mens rea for the offense? The appellant S. Means Sweet appealed against her conviction, claiming that the Section 5B required the mens rea of the knowledge of the prohibited purpose which the farmhouse was being used for. Well, S. Means Sweet accepted that the premises had been used for the smoking cannabis resin here, but she doesn't have the knowledge of this use. So, held that Section 5B of the 1965 Act did not create an absolute offense unless it is a clear intention of the Parliament that an act of an absolute or regulatory offense imposes a strict liability. The presumption of mens rea prevail over the true crime offences. The word being concerned in the management under Section 5B had to be read as the importing the mens rea of the knowledge as to the use of the premises for the prohibited purpose. Therefore, offense was a true crime is not a regulatory crime. The conviction was therefore quashed as the Sweet did not have any requisite mens rea for the offense under Section 5B of the 1965 Act. It is clear that the strict construction could be made where knowledge is more important for the absolute liability. The reason Sweet conviction was quashed in the appeal. So, these are the certain cases where we can say whether the mens rea is needed or not, where the construction of the penal statute will be strictly construed or not, that we have seen, and I have cited the many other cases also, but a few cases is enough, suppose if it is asked in the long question. But here I cited at least 7 to 8 or more than 8 cases are there. And these, at least you can cite the 5 cases that will be the more than enough for your answer. So in the conclusion, I would like to say that after the detailed analysis of the various methods of interpreting the penal statute in the online class, we can broadly categorize the method of interpretation by concluding that firstly, the basic rule of interpreting such a law should be strictly adhered to the language of the statute, since it is the will of the legislature, and the court could retain itself from the stretching the meaning of the words, causing the unnecessary hardship to the subject. Secondly, it must be always kept in mind that what is the purpose of the good the enactment seeks to achieve, and if the strict adherence is done, will be it will be able to achieve the purpose or object. Thirdly, the lastly, where you can say whether any such interpretation, the mischief which was sought to be suppressed by the penal law was suppressed. If not, then it is the duty of the court to ensure that it is done, and just because of the legislative omission, the justice to the society should not be administered. I repeat, that the legislature omission, the injustice to the society should not be administered. That means injustice means justice should be administered. That is the whole idea behind. So these are the strict construction of the penal statutes, and let us see that how the taxing statutes are there. In the taxing statutes also having the same phenomena regarding the uh, penal statute. Yes, strict construction of the taxing statute, because the tax also imposition of certain things which is in a form of financial burden. So in the financial burden, but there the penal statute is the punishment, corporal punishment or punishment to the body. So here how the system would be there, even when the construed in the taxing statute, it should be construed very strictly, and if there are two meanings are there are two interpretations are there, generally even the same principle will be used, the lenient one can be used in the taxing statutes. So before a man will be taxed over there, that he will be fixed whether he will come under the particular parameter of the tax or not. That should be very much concentrated over there. So here I made the introduction, tax system in India, taxation, the tax laws, principle of strict construction, charging section, clear intention to impose the or increase taxes, prospective operations, meaning in comprehension, meaning in common parlance, machinery provisions, no presumption as to tax, fiscal statute to be read as a whole, no spirit of law, and substance of the matter should be taken into considerations under what are the exemption clauses of strict construction and conclusion. So these are all the things I earlier I discussed in my routine classes, but in this class that I will see mostly the cases so that you could have a knowledge how the cases will be interpreted in the taxing statute and what meaning can be taken and what meaning is exempted, and when you are making the imposition of the tax on a person, then how it can be followed. So these are the things that we will see, and especially based on the cases. Now let us directly go to the principle of strict construction. Of course, I already made that whenever the taxation statutes are made over there should not be loose words should be there, and there should be very strict words should be used when you want to impose the tax on somebody else. So that is the construction which could be used over there. There is the strict construction, and let us see in the cases first. The subject is not to be taxed without clear words of that purpose. That is the CIT, commercial income tax versus the Provident Investment Company Limited, where it is clearly given. Let us see that how A.V. Fernandez versus State of Kerala. That is the one of the case law where the how the tax will be imposed on a person. That is the AR 1957, Supreme Court 657. His Lordship Bhagwati J. That is the judge has stated the principle of taxing as follows. So Justice Bhagwati said, whenever you are taxing, the principle of taxing laws as follows. I quote, yes, in construing the fiscal statutes and in determining the liability of the subject to tax, one must have regard to the strict letter of law. If the revenue satisfies the court that the case falls strictly within the provision of the law, the subject can be taxed. If, on the other hand, the case is not covered within the four corners of the provision of the taxing statutes, no tax can be imposed by the inferences or by the analogy or by trying to probe into the intentions of the legislator or by considering what was the substance of the matter. I unquote what is the Justice Bhagwati said over there. So in other words, whenever a person will be taxed over there, first he should not come under the definition of the tax. Means that in the four corners that he should be taxed, it should be cornered with the statute that he should be tax will be imposed on him or not. It should be clearly mentioned in the statutes. That is the gist of the Justice Bhagwati said in the quotation words. Let us see the Venkataramaya ESJ, what he said in the Associate Cement Company Limited versus Commercial Tax Officer, AR 1981, Supreme Court 1887. So the Supreme Court, speaking for the majority, said tax, interest, and penalty are three different concepts. Tax, interest, and penalty are three different concepts. Tax becomes payable by whom? Tax becomes payable by an SSC by virtue of the charging provisions in taxing statutes. The penalty ordinarily becomes a payable when it is found that an assessee has willfully violated and the provision of the taxing statute. Then the penalty should be imposed over him. The interest is ordinarily claimed from an assessee who has withheld the payment of any tax payable by him and is always be calculated the prescribed rate on the basis of the actual amount of the tax withheld and the extent of the delay in the paying it. It may not be wrong to say that such an interest is compensatory in character and not a penal one. So if a SSC did not pay the tax, at that instance, the delay payment would be there. Up to that extent, the tax will be imposed with the interest. That is the thing where the three words are very much important. The number is the tax payable by an SSC, and next is the interest, next is comes the penalty. So remedial statutes are known as the welfare of beneficial and social justice oriented legislation. So naturally the remedial statutes which are the welfare legislations are there and the beneficial legislations are there. Then the social justice will be given in the these statutes. The penal statutes, on the other hand, are those which provide for the penalties and for the contravention of the law and are directed against the offenders in relation to the state of making him liable for the imprisonment, fine, forfeiture, other penalties. So now we will see the penal statutes can be construed strictly. That is the ACIT versus Valiappa Textile Limited. Let us throw the light on these side headings. Of course, charging sections are there. And in the charging sections, let us see the Calcutta Jute Manufacturing Company versus Commercial Tax Officer. The Supreme Court held that in case of the interpreting the taxing statutes, yes, one has to look into what? What is the clearly stated in the statute? There is no room for the searching the intentions and presumptions or activities. So we should not draw and stretch the word meaning when the parliamentarian clearly mentioned the word, and we should not supposed to stretch it. And what is the we should not supposed to make any presumption for that one, because when they strictly construe the taxing statute, or we cannot apply our equity principle also when you want to tax when you want to impose the tax on somebody else. So that is observed in the Calcutta Jute Manufacturing Company versus Commercial Tax Officer. The Supreme Court observation made in that case law. Let us see the case law that is Mathuram Agrawal versus State of Madhya Pradesh. Yes, Mathuram, M-A-T-H-U-R-E-M, Mathuram Agrawal versus State of Madhya Pradesh. The Supreme Court held that words cannot be added. You cannot supposed to add anything to the statute. Who mean judges for interpreting. So it cannot be added or substituted. We are not supposed to substitute a particular word also when it is clear-cutly given in the statute. Or to find the meaning in a statute so as to serve the intention of the legislature. That means every taxing statute must contain three aspects. That is subject of tax. And what is the subject where the tax will be imposed? Number one, person on whom it will be imposed to be taxed, then the rate of tax. The rate of tax will vary from time to time because the financial year will changes. Then the finance ministry will make it out. Some are increased, some are decreased, as you see from the 31st March and April. These are the things where the money. Supposing the cigarettes also, if they know it that the tax will be increased more, then they will not sell the cigarette. When the tax imposition comes into the application, they will sell the cigarette. Would they do have the stock earlier? They kept it, and they'll get the higher profit later on. How the tax is imposed high in the next financial year. So now let us clearly intention to impose the increase the taxes. We will see in the different cases in different things. Let us see the one of the process of the construction combine the both the literal and functional approaches. So the process of the construction combine the both the literal and functional approaches. In the case of Gem Granite versus Commission of Income Tax, there the Supreme Court, Honorable Court observed that what one may believe or think to be the intention of the Parliament cannot prevail if the language of the statute does not support the view. Suppose the language of statute does not provide such a view, then what is the intention of the parliament? It cannot prevail over there. Thus, the object of the statute has to be gathered from the language. So, what is the object of the statute? How it can be made? So, it will be gathered from the language and not on what? On beliefs or things. So, what are the beliefs or things are whims and fancies and stretching the meaning and presumption making or equity principle are making over there that could not be done in the income tax or tax statutes. So, what are the tax statutes? Yes, that is the Income Tax Act is one of the, or any other tax which will be imposed on a person. whether the wealth tax or a house tax or the GST or any other thing, whether it will be covered or will not be covered, it should be seen over there, then only the tax will be imposed. So, Reliance due to industry limited versus commercial tax officer, the fiscal statutes are generally, I repeat, the fiscal statute, fiscal means financial year. Here, financial year, fiscal year, we will say no. Then it all related to the money matters only. So, are generally not retrospective, otherwise expressly provided by the necessary implication. Generally, the statutes which are the financial statute, which should not be retrospective effect, it should be a prospective. In the same manner, that statute, penal statute, it should not be a retrospective effect, it should be a prospective. Generally, unless until clearly mentioned in the statute. So that is another proviso would be made. Unless until it is clearly stated in the statutes that wording should have to come, then only that it will be quite good. The fiscal statute to be read as a whole. The entire provision of the fiscal statute has to be read as a whole and not the piecemeal or find out the intention of the legislature. So that is the another point is no spirit of law. A person not to be taxed on the spirit of law or logic or reason. No reason, no logic, you should be taxed over there. Then what is the exact words are there in the statute based on that thing that you should be taxed. But the person has to be taxed on the letter of the law, not the spirit of the law, not the logic of the law, not the reason of the law, but the letter of the law should be there. That means what words exactly say in the statute, that would be followed. Again, the substance of the matter, a taxing authority must consider the legal aspect of the particular transaction. For the levy of the tax, there is called a substance of the matter. On which matter that the levy would be there, a tax would be levied over there. That is called the substance of the matter. So now the exemption clauses are there. Of course, for certain things for the exemption will be there. Let us see the Commissioner of the Customs Import Bombay versus Mrs. Dilip Kumar and Company and others has overruled its 21 years old verdict given in the Sun Export case law held that the benefit of any ambiguity. Earlier, benefit of any ambiguity will be given to the taxpayer. But now the present law clearly says benefit of the ambiguity will be given to the state. So that is the thing which is happened in the Supreme Court of India in July 31st, 2018, in the case of the Commissioner of the Customs Import Mumbai versus Mrs. Dilip Kumar and Company and others, has overruled its 21 years old verdict given in the Sun Export case and held that the benefit of any ambiguity notification related to the tax exemption must be interpreted in favor of the state. That is the latest law. So in 1997, the Apex Court had said that in the Sun Export Corporation was the collector of the customs Bombay, that is the 1997, if any ambiguity in tax exemption provisions or notification, it should be interpreted so as to favor the SSC, claiming the benefit of such an exemption which is given in the earlier law. And the benefit of the doubt will be given to the SSC in the 1997, but later on when this 2018 case law clearly mentioned the 21 rules that the benefit of the ambiguity now is given to the state. In conclusion, going by the sum of the principles and cardinal points and authorities and case laws, the strict constructions approach appear to be the only guide to the construing tax statute and the strict sense and not based on the whims and fancies. There is no other whims and fancies would be there whenever the penal statutes are made. It should be strictly construed. That the same thing which I did. No stretching of the meaning, no logical expression, and no presumption should be made over there. So construing statute in strict sense, not based on the whims and fancies, by enlarging the scope and intention of the parliamentarian who enact such as tax statutes. The strict rule of the construction was inspired by need to balance the powers of the individual against the state and prevent the state from penalizing the individual unnecessarily. It is important for the lawyers or the judiciary and academician to be mindful of the above developments in the principle of construction and interpretation of the legislation because of the words used to draft the legislation are imperfect. When the words used in the legislation are imperfect at the time, it leads to the very much ambiguity will be there, where the court will play the role regarding the interpretation of such a word by the judiciary. So judiciary interferes and interpret the tax statutes are very strictly. So at the time of the judiciary, they will want to elaborate it or interpret it the tax statute. They will take the strict sense what the parliamentary having an idea to impose such a tax. And whether the tax exemption is there or not, also they will say if the exemption is there, whether it is applicable to him or not, also will be considered. Then only the things are made. So this is the roundabout in cut short manner that I made it in a comprehensive way. The both the things, that is the penal statute should be construed strictly in the same manner. Taxing statutes also be construct strictly. These are the things would be there. The time is now the 11, 12, 11. Still would you have the 4 minutes in our hand because my class ends by 12:15. Then I started exactly my class at 11:30. And if you want to ask any question, that you can ask me. So I told you that my principle is even one person also will be there, I will continue my class as if there are 100 persons are attending my class, because my mission is if one person also get benefit out of my class at that time, I think that my mission is fulfilled. So that is my intention and that is my motto. And my motto also that my knowledge should not die with me, it should be imparted to other person. So knowledge will be disseminated rather than buried in the grave. That's my point. So, any other question that you would like to ask, you can ask me, and then I can give the reply to the questions for your things. Yes, anything to be asked, please ask me. So,
No,
the
sir.
other,
Thank you, sir.
yes. So with this, so the tomorrow again I will take the class in the same timings, and I will also put it over there, which I did not cover it, which I feel it is very much useful to you. So that I may cover it, and I will put it in advance that what I am going to cover. In the today night again I will make the repetition and the reminder to you for the next day, early hours also, so that the people will at least read and they will participate. They will understand what I am explaining and what I am reading, what I am explaining. At least they could know it. Otherwise, what I say something and they listen something, and both the way we cannot reach the destination. What which we want to reach the destination. So with this, I would like to wind up my today class, and thank you very much for the patient listening. And let us meet in tomorrow in the same timings. For the absentees, I can post it the YouTube also the same class.